Hello, I'm Crystal Juga, founder of Juga Law PLLC. We are an estate planning law firm here in New York City. And the question of the day is, all of my accounts have beneficiary designations. Do I really still need a trust? So recently I've been running into a lot of situations where people have died and left their families with a big mess because they've relied on beneficiary designations, or I've come across people who are thinking about estate planning and they've been given some advice about beneficiary designations that really hasn't been the greatest. And this has typically led people to believe that if they set up beneficiary designations the right way, that's all they really need to do to ensure that their assets are passed the way that they would like if something happens to them. And really what I found is this is just giving people a false sense of security that everything is taken care of, when in fact that's really rarely ever the case. So this situation usually arises when they don't own real estate and all of their accounts can be handled with beneficiary designations when they pass. So first, let's talk about the big elephant in the room here. What exactly is a beneficiary designation? And I'm sure if you're here because you're considering beneficiary designations as the foundation of your estate plan, then you're probably already aware of what a beneficiary designation is. But for those of you who might not know, beneficiary designations they're available on a lot of different types of accounts, and basically it's where you can complete a form with a financial institution in most cases that says where you want the assets that are held in that account to go after you pass away. And really the great thing about them is, one, they're fairly easy to set up, and generally they get paid out fairly quickly after someone passes if they're done the right way, and they avoid probate. So that sounds great, right? So if all of your assets have beneficiary designations, why would you ever need to set up a trust? And while there are a few situations where you still might need a trust to accomplish your goals, even if you name beneficiaries for everything you own. So today I'm going to go over, I think, 8 questions that I have that you'll want to ask yourself to figure out whether or not beneficiary designations might not be enough for you, or if a trust still might be your best option. So the first question you want to ask yourself is, do you want to leave any assets to minor children? That's kids under the age of 18, and this could be your own children or your grandchildren if you'd want your grandchildren to inherit anything somewhere along your succession if your children pass away before you. And if the answer to this question is yes, I want to leave something to a minor child, you might still need a trust. If someone is not a legal adult, they cannot inherit under the law. So if you have a minor, someone not under the age of 18, named as a beneficiary on any of your accounts, and you die, the financial institution is not going to write a check to the beneficiary. It's not legal. So now that asset that would typically avoid probate because it has a beneficiary, it has to go through probate, which is a court process, to establish a legal guardianship to determine who's going to manage the money until the beneficiary becomes an adult. And I've actually seen a lot of cases where a married person names their spouse as beneficiary of 50% on an account, and then minor child as the beneficiary of the other 50%. And then the surviving spouse has to actually apply for guardianship to control the assets that her own kids were the beneficiaries of. So this is typically why I tell people never name minor children as beneficiaries. If minors are part of your plan, then you might want to consider setting up a trust. Question 2 that you'll want to ask yourself: will beneficiary designation form actually get your assets where you want them to go when you pass away? And this is a question that people usually evaluate their options kind of backwards. The beneficiary designation forms are pretty limited on how you can distribute your assets after your death. So when people see they have these forms and these options on their accounts, their first instinct is to, I'm going to complete this form and then make the rest of my plan work around the forms. In reality, what you should be doing is your analysis the other way around. So you ask yourself, what do I want to happen with everything when I die? And most people, if you have kids, would choose for their assets to go to their children. And then you can't just stop there. You have to take that analysis a couple steps farther. So you would ask, if one or more of my children die before me, I know it's a horrible thought, nobody wants to think about it, but it's important. So if one of my children passed before me, what do I want to happen to their share? Typically, people choose either go to their children, my grandchildren, their children, or to my other surviving children. Once you've answered that question, you can't just stop there. You then ask yourself, if something happens to one of your children and they don't have children or grandchildren or any living descendants, what would you want to happen to their share? Now, usually people want it to go to their other surviving children, but then you ask yourself, okay, right now, I'm only considering family members who are currently in existence, people currently alive. What if my children have more children? Or what if I have more children? Then what do I want to happen? Once you've answered all of those questions, then you can sit down with your beneficiary designation forms and try to figure out, does this form carry out my wishes? Now, unless your family is very small and is not likely to change, then the answer to that question is probably going to be no. The form cannot carry out your wishes. So if you've established that the form can't actually do what you want, then you have to try to figure out what can the form actually do. And I'm going to tell you that each form is completely different at each financial institution. They all have different rules. So you have to look at each form for all of your accounts. And once you figured out what those forms will actually allow you to do, and I'll give you a hint here that most beneficiary designation forms don't actually give you many options and contingencies. But once you figured out what you can do, then you decide if you can live with that or whether it forces you to give up too much of what you actually want. Once you've figured it out, you realize, okay, it's not the best choice for me, but I can live with it. I can live with these options. That's fine. Go ahead and move on to the next question. If you've decided you can't live with those options that the form allows, then a trust might still be right for you. So now the third question you should ask yourself, do you have any potentially disabled beneficiaries? And this applies to whether you have anyone who has a disability now or to anyone who might become disabled before you die. If you have a beneficiary who is disabled, you might want to consider a trust because adding a disabled person as a beneficiary can disqualify them from getting Medicaid and other benefits to help with medical costs. Question 4, do you want to protect or preserve assets for any of your beneficiaries? If the answer to this question is absolutely yes, then you'll definitely want to consider a trust. If the answer to this question is how or why would I want to protect their assets, then keep listening. So one reason you might want to protect assets, it could be that one of your beneficiaries might have creditors knocking on their door, or they're going through a lawsuit or a divorce when you pass away. And a beneficiary designation offers you no way to delay their payout or structure it in any sort of way to prevent all of the assets from being taken. Also, there might be a situation where your kids or your grandkids are really young adults and you don't want to give them full control of the money right away. Maybe you'd want to let them take half of it immediately and the remainder when they're a little bit older and more responsible. You can't do that with beneficiary designations. You also can't give any instructions for how you would want the money to be used. Or let's say you do leave assets to your kids, and you want them to use it for whatever they need throughout their lives. But if there's anything left when they pass, you want to make sure those assets go to your grandchildren. You can't do that with a beneficiary designation form. So if offering any of these types of protections to whoever inherits your assets sounds appealing to you, then you might want to consider using a trust. The next question, do you currently know who is named as primary and contingent beneficiaries and in what order on every account that you own? Now, if the answer to this question is no, that's a pretty good indicator that you're not staying on top of your beneficiary designations, so you might want to consider a trust. Question 6, do you know without question that you will remember to update your beneficiary designations anytime your life changes? And when you have a new baby, if you have a new grandchild, if somebody passes away, if somebody becomes disabled, if someone develops a drug addiction, will you remember to go and update them? And will you remember to go update your beneficiary designations on all of your accounts? And if the answer to this question is, I don't know, or I don't think I'll remember, then consider creating a trust instead of just relying on beneficiaries. Next question. Do you want to make sure your legal, financial, and business affairs are as easy as possible for the person you choose to manage it if you become incapacitated? So if you're sick in the hospital, you can't manage things on your own. If the answer to this question is yes, then you might want to consider setting up a trust. Even if you have the most comprehensive power of attorney possible, banks prefer to work with successor trustees over an agent named in a power of attorney to protect themselves when somebody comes in with a piece of paper trying to get money from your accounts. So typically it's a lot easier for whoever you have named to manage your business and financial affairs to be a successor trustee than come in with a power of attorney. And the last question is, are you sure that all of your assets allow beneficiary designations? In a lot of states, and this is very state specific, vehicles or real estate don't have beneficiary designations. So there would be no way to pass that on at your death without setting up a trust. You can't do it with a beneficiary designation. In some states you can. Again, that's very state specific. So if the answer to this is no, or I'm not really sure if all my assets have beneficiaries, consider setting up a trust. Now, maybe after you answer these questions, you're saying to yourself, but what does it matter if my beneficiary designations don't work right or aren't that flexible? Isn't that why I created a will? And the answer to this question is absolutely not. Your will does not even apply to any accounts where you have a named beneficiary. If you have a beneficiary, that's a contract you've made with the financial institution, and that controls. It doesn't matter what your will says because it will never be consulted. The only time it would be consulted is if you haven't named a beneficiary, or you've set it up the wrong way, or you left a minor, and those assets get pulled into probate court. Then your will would control through the probate process. So these are just some things to consider when you're creating your estate plan, especially if you're considering or you've been advised to rely on beneficiary designations as the foundation of your plan. Now, obviously, you don't get any legal advice when you're filling out these beneficiary forms because you're not usually speaking to an attorney. So they can seem like a great idea in theory. In reality, I've seen a lot of family members who are now stuck in court and conflict because their loved ones thought they had taken care of everything with beneficiaries, and that plan sort of backfired and left their families with a big mess to clean up. So if your answers to these questions have you thinking that beneficiary designations really aren't the best plan for your family, go ahead and comment below to let us know, or give us a call at 929-415-8700 to schedule a time to chat about your situation. Or if there's another topic that you have questions about, let me know. We're happy to do another video. All right. Well, thanks for watching, everyone. Have a great day.